The agency relationship agency law explains who you represent in a transaction and what duties arise once that relationship is formed. Every listing agreement, buyer-broker agreement, and property management contract creates an agency relationship built on trust. The principal is the client, the person you represent. The agent is the brokerage, acting through its licensed associates. The customer is the unrepresented third party who must be treated honestly and fairly, but who is not owed loyalty or advocacy. For example, if you are the listing agent, the seller is your client, and the buyer approaching you directly is your customer. You must treat them honestly, but your loyalty remains with the seller. Levels of agency authority. Universal agency gives the broadest authority, such as a power of attorney that permits someone to make almost any legal decision for another person. General agency covers ongoing activities in a particular business, such as a property manager who handles renting, repairs, and tenant relations. Special agency is the most common form in real estate. A listing agreement creates special agency because the broker is hired only to market and negotiate the sale of one identified property and does not have authority to sign contracts for the seller. How agency is created. Express agency is formed through an explicit agreement, usually written, such as a listing or buyer-broker employment agreement. Implied agency is created through conduct. If a licensee repeatedly says to a buyer, "I'll protect your interests," and negotiates only for them, that licensee may accidentally create implied agency even without a written agreement. Apparent authority arises when a principal allows others to believe an agent has authority, and third parties rely on that. Ratification occurs when a principal accepts an unauthorized act after it happens. Estoppel prevents a principal from denying agency if the principal's conduct caused others to rely on that person's authority. Fiduciary duties. Once agency exists, the agent owes fiduciary duties to the client. These include loyalty, where the client's interests come first, obedience to lawful instructions, full disclosure of material facts, confidentiality of the client's personal and negotiating information, reasonable skill and care in performing real estate tasks, and accurate accounting for money, documents, and property. These duties apply from the moment agency exists, whether written or implied. For example, you must never disclose how low your seller is willing to go, because doing so would violate confidentiality and loyalty. Duties to customers. Although customers are not clients, agents must still treat them fairly and honestly and must disclose known material defects in the property. The agent may not give false assurances or misrepresent expertise. For instance, telling a buyer, "I guarantee the property will appreciate," is improper and creates liability because it misrepresents your expertise. Forms of agency. Single agency is when the broker represents only one side, either the buyer or the seller, and owes full fiduciary duties to that party. Subagency is an older concept where cooperating brokers represented the seller even when working with buyers. It has largely disappeared because it confused consumers. Dual agency occurs when the same broker represents both buyer and seller in the same transaction. Dual agency in Arizona requires prior informed written consent because the broker cannot fully advocate for both sides at the same time. Confidential information, such as bottom line pricing, may not be shared between the parties. Transaction brokerage or facilitation involves assisting both parties without offering fiduciary representation. Arizona does not formally adopt this model, but has situations where a party may remain unrepresented while still receiving fair and honest treatment. Agency disclosure rules. Agency disclosure helps consumers understand who the agent represents. Disclosure must be made at the first substantive contact, which is when conversations move beyond simple facts and begin involving confidential information or negotiations. Sellers must be told that the broker represents them, and buyers must be told that the listing agent represents the seller. Buyers must also be informed if the buyer's broker represents them. In dual agency situations, both parties must sign written consent before the dual representation begins. Listing brokers must disclose buyer performance concerns, their own personal interest in the transaction, compensation arrangements, and all known material defects. Buyer's brokers must disclose defects, seller performance concerns, potential liens, personal interest, and compensation. Certain Arizona topics, such as military airport disclosures, criminal activity, and stigmatized property laws, also guide what must be disclosed.